點樣選主席
Right, election of chairman. Dennis. I nominate Dennis. Any objection? Okay. Thank you.
係咁，我哋進入議程嘅第二項，好唔好啊？
All right, shall we move on to agenda item number 2? Let us invite the administration and the representative of the Law Association, Law Society rather, Law Society to enter this room.
佢哋講有冇 paper 要講，定係就咁講自己立場？
叫佢 bring us through a paper。
邊個 paper？
解釋下，其實佢要加減嗰啲咯，譬如佢點解要加，點解要減，點解要咁樣改嗰條例，叫佢解釋下。即係逐條咁go through。我哋通常叫佢吉標明文法。
Hi, how are you? Mr. Cohen.
Good.
Thank you for coming. If members don't mind, I would like to invite Mr. Colin Cohen from the Law Society to basically update us on the latest position regarding these rules and to give us the Law Society's latest position on this matter. Thank you.
Thank you very much, Mr. Chairman. First of all, I think there needs to be some apologies here for the extensive delay in respect to this matter. And mea culpa will come from our end in respect to this, because the delay since last time we were here in 2005 has been a very, very long time. The changes since 2005 as to what we're facing today are not very large. What we have done over the time is try to modernise and update these very, very difficult rules, the accounts rules, which nobody likes. I mean, it's quite interesting. I examine accounts, and every single student and every After Matters all say, please abolish this subject, because it is a difficult, intricate matter. The object of these rules was an attempt to codify everything under one section of the accounts rules. Previously, you had to go to Part A, to practice direction, to this direction, to that direction. So what you've now got under the accounts rules is one set of all the rules together. We took on board the comments that were made to us last time we were here in respect to the interest. But with great, great respect, the interest provisions is one great big red herring, because with regard to the current rates of interest at 0.1%, for these to have, even for example, I'll give you an example. In my firm, which is a medium-sized, largish firm in Hong Kong, 16 lawyers, we have in our client's account every month approximately 35 million to 40 million Hong Kong dollars. The interest on that, I did a bit of research before I came here with my accountant, how much interest is due on that whole amount? $55 last month, $48 the month before. If we're going to try and get more than $500 on a 4-day period, you're going to have over 6 billion Hong Kong dollars in your client's account to even get the $500 in that amount. So at the moment, with interest rates being so low, I think all of this becomes a very academic issue per se. Once interest rates ever get back to the 5%, and goodness knows when that will be, I think we're going to have to talk to the Americans about that. I don't see that happening for many, many years. Then the system we have in place now is clear, unequivocal, how it works out in respect of matters as well. The other provisions here, I think, are just very straightforward. It's definitions more than anything else. Yeah. I have to thank the DOJ, who have been very, very helpful. I mean, fortunately, we in the Law Society, my technique on drafting isn't very good. They've been very, very helpful and they've responded very, very efficiently to anything we've put to them. The problem been over these years is that nobody really gave this matter the real attention it's needed. You put accounts on the back burner. It's not, how could I say, this is not the most, pressing matter that happened. There was a change in the committees. I took over from the last chairman, Mr. Michael Linton-Smith. The Consumer Council sat on matters. The Chief Justice, when he got the previous Chief Justice, sat on matters. But I don't want to push the blame. Apologies. It shouldn't have taken that long period, full stop. So, I'm delighted to go through in great detail these rules. I'm delighted to take any questions people would have to ask. I mean, those solicitors here, I'm sure, are very familiar. I used to examine them, I think, if I remember, when they were at Hong Kong University, and I still examine on this subject. So I'll be able to take up any questions on any matters as well. I hope I've given it a bird's eye view, Mr. Chairman, unless you want me to say anything further.
Thank you, Mr. Cohen. 不如咁啦，我請咗。
Well, if I may invite the representative of the DOJ to speak, and then open the floor to members to ask questions, and then I will deal with the rules per se. This is English translation. This is English channel. Is it getting through? This is an English channel.
Yeah, just like to thank Law Society for the clarification about DOJ's role in this matter. Because
開咪，開咪。有冇咪啊你？得，你或者埋少少。Thank you。
都可以係。咁或者我用返中文。
If I may switch into Cantonese. Thank you, Chairman. First of all, I'd like to thank the Law Society for clarifying the role of the DOJ. The set rules were established by the Council of the Law Society with the agreement of the Chief Justice. So our role is just a supporting role. Because of our role, we give some observations and comments. At the end of the day, how the drafting is to be done, and also the policy behind that, are all the responsibilities of the Law Society. But it doesn't mean that we don't have a role to play. I just want to set out the division of labor. For broader legal policy matters, we may also give our views. In fact, I have one question concerning the calculation of interest. And when we come to that specific provision, I can give my view. As usual, we do our best and respond as early as possible. I'm glad to see that Mr. Cohen has already clarified this point. Now, do members have any questions? Not for the moment. Then, our legal advisor. Now, you may be most familiar with the issues. And on what points have they not reached any consensus? If you may refer to the markup copy prepared by us, LN 151. Do you have LN 151? The markup copy. On the right-hand side is the proposed amendment. On the left-hand side is the original. Perhaps the Law Society can take members through the paper and then explain why there are the amendments and the reasons for the amendments. And then, at appropriate juncture, I will highlight the places where there are differences between the two parties. And the paper number is CB4139121305. Page 0001, the first page. Would the Law Society explain why you need to add principle?
The reason why we did all of this is for many reasons. First of all, we looked at other very similar legislation in other jurisdictions to help members. And the object of all of this is that if you are, let's say, in Hong Kong, as you know, you can open up practice after 2 years. So if you're a newly qualified solicitor, after 2 years, you become into partnership, you want to have something very, very clear that sets out what the rules are. So 1A is basically putting in some definitions and some principles as to the fundamentals of keeping your money separate from office money. It is very, very straightforward. I mean, it basically says that how does one run one's solicitor's accounts? To run one's solicitor's accounts, one starts with basic principles. And the basic principle is the holy grail of solicitor's accounts: thou shalt not use client's money other than for client's purposes. And you've got to have it all set up in such a way that it's clearly identified and dealt with. The reason for having all these particular definitions, and I presume you want me to go through all of this, is to basically say that in the event of trouble happening, and in the event of the occasional bad apple, and then when we got to rectify matters, we can make it clear that you know from the very beginning what you do with regard to the principles of keeping your money separate. So you can see little a through little j makes it very, very clear as to what you want to do. And and our point of view was to make sure that the members of the Law Society, who have to have your bookkeeping, computer or otherwise, have these clearly set out. So that deals with 1A and the principles in respect of other matters as well.
Yeah.
And I think that's a very, very good way of dealing with it. Most other jurisdictions deal with it, and it makes it easy for the solicitors to know what they're doing.
Thank you, Mr. Cohen.
或者律師公會可以解釋下，而以第1A 條。
Perhaps the Law Society can explain to us in relation to proposed 1A, is it new or is it in the practice direction?
Rules. For example, in Rule 1A, small a, it refers to the solicitor practice rules.
Yep.
For example, in little j, the deliver annual accountant's report, it reflects the section 8 of the legal petitioner's ordinance.
Let me help out. I think if you remember what I said at the very beginning here, you asked me why we're doing this. As I said beforehand, you had practice rules, accounts rules, indemnity rules, all over the place. We wanted to put into one document the fundamentals of the solicitor's accounts rules. Well, let me put the question to you. What's wrong with it doing it this way?
I think
I'm a bit confused here because, as I said at the beginning, I don't think it, I'm saying to you, I thought we can all read, we can all think, we can all go through this very clearly, you know, solicitor must do A, B, C, D, J. All of this is fundamental. Either it was in the rules previously, either it's good common sense, and it was taken from some other matters, which I looked at the English rules, the Australian rules, and we said, oh yeah, this looks quite a good idea to put this at the very beginning, and it makes a lot of common sense for people. So you have something at the very beginning which tells a solicitor how important it is to keep your client's money separate from your office money. So unless we could we be more particular as to specific areas in which you have a gripe with, and I can answer those specific areas, which makes it far more better for me to come here and try to help you out with that. These are just principles, and principles are principles. So if you have an issue with this, tell me what the issue is, and I can address each one. Don't want to sound to be difficult, but I am very, very busy at the moment.
Yeah, thank you, Mr. Cohen.
Because there is no.
Perhaps you could do this in English. It's easier for me to hear it in English from you.
No information note has been provided to us. So in order to assist members to understand which part of the proposed rule is new and which part are from existing practice directions, we just want information coming from the policymaker as to highlight the new parts to the members for them to consider.
Okay, let me help you out with that. A, previous. B, fundamental principle summarizing. C, if I recollect, is summary, wasn't before. D, summary before. E, general summary. F, general summary. G, practice direction. K, practice direction. I, general summary. J, previous Council rules.
Thank you. It seems pretty fundamental and understandable to me. So unless members have any questions, we'll move on to the next item. Thank you.
So you want me to go through the interpretation?
No, it's okay. We'll let the legal advisor handle this.
Okay.
Unless there is anything, we'll ask for your assistance.
Fine. I think that's far better and far more efficient, so I can just answer your questions
Yes,
as to what's...
that's the way we're going to do it.
And we did write quite a long letter, if I recollect, in respect of all of this, and saying, yeah, we do accept certain things, giving our views.
Yeah.
If we turn to page 2 of the markup version, proposed amendment to Rule 2, the first line, we see a term, a current or deposit account. It is noted that here the rendition for deposit account is 儲蓄戶口, which is the same as the rendition for savings account, also 儲蓄戶口. And inquiry has been made with the Law Society as to whether different words should be used. And I noted from the banking ordinance that the rendition for deposit account is 存款戶口, whereas the rendition for savings account is 儲蓄戶口. And would the Law Society please reconsider whether it would be consistent with the existing law to adopt different terms for deposit account and savings account?
呢啲咁樣 queries 咧，有幾個想講？
都多㗎，咁佢全部我哋 raise 咗俾佢咧，佢都。
Where's the answer to it?
Well, I've just been informed by Ms. Wong, the legal advisor, that similar nature of queries, there are about 10 to 15 of them. Now, I think it will be quite a time, not a very efficient use of time, if we are all to sit here and go through them one by one. Now, the Law Society, correct me if I'm wrong, has been provided with a list of these queries. So all we need from you, really, is...
For November, we wrote a nice letter, which I saw, trying to answer all of these. Have you seen my letter, or our letter? Yeah. And I think we've answered them all. I mean, frankly speaking, if you want to come up with a better wording, which you think is going to be, I mean, splitting hairs, you know, it's not going to get anywhere. You know, I mean, this is why this matter's been delayed. I mean, I think in the end of the day, I'm quite happy to put in it whatever's going to be easier for the normal person to understand. We're talking about, you know, the working party considers not necessary to make any change on the first one, but you know, if you think if someone else at the DOJ or someone else thinks it will help the solicitor or the member of public, then by all means, you know, I mean, it seems to me quite an obvious matter as to what is a current or deposit or savings account. The issue is you put your money in a bank account, and that's normally a savings account because that's where you get the interest on as well. It has to be a bank in Hong Kong. So any ideas of it not being a bank in Hong Kong, it's covered later on in the rules, says it must be a bank in Hong Kong. But, you know, I mean, I'm open to any views in respect to this if it's valid. I think we answered that saying, well, we don't think it is that necessary. But, you know, if you want to change it, if it's in the best interest of the public, by all means. I don't think it is. I think the rules are clear.
Let me clarify. As the legal advisor to this subcommittee, I've already set out my observations in my letter to the Law Society. And they basically came back somehow not answering our questions or not accepting our recommendations. And there are some obvious, and there are some places where the Chinese and the English text of the proposed amendments or the proposed law have different meanings. So that's why I take the time to bring it to members' attention. And and it depends whether the Law Society will take it on. And I can see the difficulty because Mr. Collins doesn't understand Chinese. And a lot of this is on the rendition of the Chinese text and the English text.
The answer to all of this is very, very simple. Those just below me, I trust them implicitly, the DOJ. They're the experts on getting sure the translation is correct and dealt with. And I know they're very, very helpful. Perhaps they've come back with some comments saying they don't think they're too worried about it. But surely the best people to make sure there's no... I agree with you entirely. There mustn't be any difference between the translations.
Yeah.
And I can't, I can't deal with that myself.
Thank you, Mr. Cohen. Just one second. Anything from the Department of Justice on this?
Thank you, Chairman. Again, we would like to clarify our position.
Yes.
The Law Society Council is actually the maker of this subleg, and we've given our comments. The law drafting colleagues have passed our comments to the Law Society Council. I can further say that on, for example, the first issue relating to this definition of client, the meaning of deposit account or savings account, I note the exchange between the parties, and we believe that this is something which the Law Society could maintain their view rather than following the suggestions from the legal advisor. But I note from their response, in fact, there are a couple of places where the Law Society is prepared to amend the draft. For example, at page 4 of their letter of the 7th of November and page 5, there are two places, two items which the Law Society consider appropriate to amend the draft rules. And of course, ultimately, if members here feels that there's a need to make further changes, it's really open to members. But on my part, I think there are some issues I'd like to make it quite clear are really, within the discretion of the Law Society Council. We do not have a strong view either way. But if, for example, Chairman feels that the suggestions could be further considered by Law Society Council, we will be happy to provide further input to the Law Society Council so that perhaps some amicable arrangement could be reached on the technical renditions. Because, sometimes we do not feel that they must be amended, but I think it's sometimes perhaps a...
So you don't have a firm view either way on many of these amendments. Can I take it?
On most of those, we feel that there's no need to change them. On specific issues, on a few of those, I can read from my colleagues' comment from the Law Drafting Division, because I come from the Legal Policy Division, looking at the broader legal policy issues. But on law drafting points, I understand that my colleagues have passed their observations on a few places where, they are open to changes, but I think it's really up to Law Society Council to make a final decision, of course, subject to the subcommittee's power of amendment.
Sure. Okay, so I understand your position quite clearly. Thank you. So in order to shorten the process, shall we just focus on the parts where there is not yet a consensus between the parties? But having taken into account what was just been said by the Department of Justice, that they don't have a firm view on most, if not all, of the issues raised.
In a sense, Chairman, perhaps to clarify that, we would say that most of those points helpfully raised by the ALA will not necessarily require amendments. There may be a few points, a couple of points actually, that would be up to Law Society to consider further, perhaps, whether to make those amendments. Unless Chairman would like me to go into details, but I think Law Society would be in a better place because they have considered it, I understand, through their working party. So they have taken into account our comments, our law drafting colleagues' comments, before responding on the 7th.
Okay, thank you. So Ms. Wong what she will do now is to just go to those few more difficult or controversial ones, if I may put it that way, and to cut short the process. Is that okay with members? Thank you. Ms. Wong.
Yes, at page 0007 of the markup version.
we're looking at the same paper. Thank you.
I wish members to look at the Chinese text, 0007. LN1 is still on 151. LN 151. The rule is Rule 9 on exceptions. If you just read the proposed amendment to Rule 9, bracket 2C, small letter 1, the Chinese part, it is not readily comprehensible. May I read it out in Chinese? 已有一份事務費單或關於事務費款額的其他書。
For any part of the payment that is for disbursements incurred but not yet paid either. If you just read the Chinese version, then you won't be able to understand what the Law Society is trying to drive at. So, Ms. Lee, from the Law Society, will you be able to help us here? In fact, in our letter, dated November the 7th, we have already addressed that point. That is about Rule 92C1 with regard to the Chinese rendition. And based on DOJ's advice, they also agreed that there is no need for us to change it. But here, so what are you trying to suggest here? So are you saying that the solicitor, with regard to the receipt or the amount, are you giving that to the client? But then if you read the Chinese rendition with regard to payment that is for disbursement incurred but not yet paid. But then if you read the Chinese rendition, you will not be able to understand it. So are you referring to the account or whatever? So are you asking the client to pay the amount, or are you asking the lawyer to bring a receipt involving the amount and then head it over to the client? Is about the receipt. So I do agree that there may be some problems with the Chinese wording. Well, in the Chinese version, they refer to 已有一份事務費單. And also, the 已有一份書面費單. That is a written notice or written intimation of the amount of the cost has been delivered. So if you just read the Chinese rendition, you will not be able to understand it. If you read the English version, yes, you understand it, but then if you have not had the benefit of reading the English text first, then if you just read the Chinese text, then you will not be able to understand it. Mr. Paul Chair. Legal advisor, are you referring to a part that has been crossed out? Is it one of the phrases that has been crossed out on the left-hand side? No, I'm referring to page 0007. Page 007, the right-hand column, 1 and 2. The first sentence. In respect of which a bill of cost or other written intimation of the amount of the cost has been delivered. So it's about the Chinese rendition of this clause.
Ms. Abbott-Ho. Well, my response to that is, it is a written notice given to the client. Or it's a document given to the client. That's my reading of that in Chinese.
Sorry，主席係咪可以應該？
這位質議員。
Yes, Mr. Poche. Can we change the word order to make the rendition, Chinese rendition, easier to understand?
係。
李小姐，你
Ms. Lee, do you think Mr. Chair's suggestion is acceptable?
事務費單
And there is a change in word order.
費款項的其他書面告知。
係啦，即係將個交付。
And the term in Chinese 交付 is moved forward.
呢個要慢慢翻去再諗，呢個要慢慢再翻去再諗嚇。
黃先生。
Mr. Wong, we are not giving any legal advice to the Law Society concerning members' views proposed today. If the Law Society wants to get some observations from us, we are willing to help. Now, if the Chinese version is to be changed, then the English version may be affected because it says it has been delivered. My colleagues who read this considered that there was no need to change, but if members want to look into that further, we are happy to assist. All right.
The money, it's when you're putting the money into your office account or your client's account.
But Mr. Cohen,
It's very
Mr. Cohen,
straightforward.
I think we're not in difference over matters of principle. Rather, it is the use of the exact wording in Chinese that is causing the problem.
Can't there be a proper I'm sure someone can translate it.
Well, I'm sure it can be done. It has, or it will be done already. But I think we've heard the comments made by the Honourable Mr. Poche and the legal advisor and also the Department of Justice. Can I put the ball back to the Law Society on this particular provision?
Absolutely. I think what we can do is try to have get this all sorted out by sensible corridor. So it seems to me this should be done very, very quickly.
Yeah.
It's a mere format.
It's a mere
exactly.
twist of the wording. So this one you've got.
Yeah, absolutely. We have no problems with that.
Yeah. Okay, so shall we move to the next controversial?
We'll try and get wording which we're happy with.
The next one is the following one. Proposed Rule 2A on page 7. If you look at the proposed 2A, you will see that the solicitor must do A, B, C. And then if you look at small Roman 2, it says a solicitor must do this, failing which the payment should be paid in the client account not later than the 5th working day following the receipt. Can the Law Society explain why, if something is made a mandatory requirement, a solicitor must do this, and there is a failing which, and the failing which provision is followed by the word should. So is it really a mandatory requirement in the first place?
Yes.
Mr. Cohen.
Yes, well, let's look at it very clearly. What you've got here, if you've got a situation as a solicitor where an amount of money comes in, and it's, let's say, the client gives you $100,000, and of that $100,000, part of that is for counsel's fees. You then have the decision as to where that money goes. And as you can see, if it includes a disbursement as well as a client's money, whether it's meant to be for a bit of both, you then decide what it is. You then decide whether you can split it or whether you can do that. And if you can't, sometimes it goes into office, sometimes it goes into client. If there's any doubt, you put it into client within a period of time. The problem is, why you need that, is it may take some time. The reason why you put the 4 to 5 days are, because everyone knows as solicitors, sometimes there's uncertainty as to what exact that money consists of and what that money is for. And that's why that extra time is needed.
Thank you, Mr.
It's as simple as that.
Yeah. 委員有冇問題？
Any questions from members concerning this point? Ms. Albert Ho.
5 days may be too short.
Well,
Because the solicitor may have to sort out the relevant, say, fee notes or invoices before.
yeah.
So I
Well,
just
your point's a very good point. People on the committee raised that, and in the end, because of the comments that this is so important, it means you've got to turn to it within the 4 to 5 days. Remember this, there is that saving rule whereby, you make a mistake other than clerical mistakes. So you've got to have a time period, and if you go any longer than that 4 to 5 days, working days, which is actually 4 to 5 working days is taking you into more than an actual week, actually, if you go over that. So yeah, that's not it's a point that was raised, and in the end, like committees, you find that you got the people with different views, and we thought that was the best timing. If you feel that it should be a little bit longer, I don't quarrel too much if you want to change it to the 5th to the 6th or something like that. But you wouldn't want to go... I mean, Mr. Chair, both of you are very experienced solicitors. I think one knows... The problem is this one, is the client gives you the X dollars, and you're not too sure, well, some of it is for this thing, some of it is for that. And you've had that before in practice, I'm sure, Mr. Chair. And Mr. Hay, I mean, you've had that problem many, many times. So we think that was the easiest way to work it out. In reality, this is not going to happen because everybody just puts it straight into their client's account and then sorts it out later.
Right.
And that's what happens, which you can do. You'll never, what you'll hear there, you're not in the breach if you get it into the client's account, okay?
I suppose the rationale here is if in doubt, put it in the client's account.
Correct, absolutely. And really...
The bill ready, otherwise you don't put it in the office account.
Exactly. And this idea of we put in these rules because they're there for the exceptions in respect to matters as well. So they're there because they're there, and this tidies it up in a bit. So I think...
Okay, all right.
Yeah, I hope I've answered your question.
So no question on policy, then we return to the drafting issue,
Yeah,
right?
I think we are, it's all clear now, I think, on this one, and we can move on to the next.
Excellent.
Sorry, so is the legal advice suggesting that the word shall should be used instead of should?
I'm just thinking about the logic, because if something is made mandatory, then the logical consequence is there will be a sanction following. Or so you must do something, otherwise a sanction. But now what the Law Society is proposing is you must do this, failing which you should do something. So it seems to
Weird.
is it really a mandatory requirement? That's my question.
It is, because we're giving you the exceptions. What we're saying to you, you determine what it is. You then decide whether it's going to go into the client's account or not the client's account. Now, if you're not too sure, then you do this. So the fundamental mandatory is the first step is to determine what that money is for. Once you've determined what it's for, then you deal with it in accordance to the rules. So I'm not too sure whether we're getting close to splitting the hair a bit, but I don't think it's a real issue here, frankly.
Because in legislation, we usually talk about what you may do, what you must do. It's uncommon to talk about what you should do. What you should do is usually in a practice direction. So but it's a policy.
Yeah, but
matter.
the problem here is you've got anticipated disbursements, you see, and it's not crystal clear. So it gives the flexibility. You determine it. If you're not then sure what it exactly is, then you do with it. See, in practice, money comes flying in from clients. You've got a surveyor's report to do. You've got the costs on account. You've got council's fees. Numerous things happen, and even they're going to pay your fee notes out of it as well. So if it includes a disbursement as well as clients' money, so for example, we want you to pay council's fees and they want you to put money on account of costs. So I'm giving $100,000, of which so much is for council's fees and so much is on account for the future. Now, you've got a choice of where you can do that as well, and that's how it works. And it's really the crucial issue is 2A. A solicitor must then do A, B, and C. Once you get to C, if that part is for disbursement incurred but not yet paid, either pay that payment in the client's account or pay it into the office account within that certain amount. So I think it's a logical procedure that if you're a solicitor and you know how to deal with clients' monies, you're a lot better now than you were before when it really wasn't a mess what you should do with it as well. It's the nature of the beast we're
much
talking
easier.
about.
We simply change the word should to must then. Third last,
Failing which the payment must be paid into
that will solve the problem in legal
the client
advice, wouldn't
account.
it? And without changing the flow of the...
Instead of failing which the payment should, we change it to failing which the payment must be paid into the client account not later than the 5th working day.
I'm happy with that.
Yeah, that would be consistent with the logic, and
Yeah.
the legal advisor will be happy with it, I hope.
Thank you, Mr.
I'm
Chair.
happy with that. Yeah, I'm very
The
happy
Law
to
Society
keep,
is happy with
I'm
that?
very happy to keep the legal advisor happy.
Okay, well, so everyone's happy.
Points here.
2 small points.
Here we are talking about the 4th working day and the 5th working day, and I think the proper rendition should be 第4個工作日、第5個工作日。It's not 4個工作日、5個工作日。
即係中文嗰度加返個第字。
So the Chinese, the 4th working day, in Chinese it should be 第4. So the Chinese, we add 的第4個工作日. Is it okay, Miss Lee? No problem? All right, then both the English and Chinese renditions are okay, and they are acceptable to all. Is it okay with members? Right, then move on. The 3rd point.
What are we on to now? Yeah. Obligation to keep accounts, yeah.
Yes, obligation to keep accounts. Here, we have sent a letter to the Law Society inquiring what the qualification modifies. The qualification is that are necessary for the operation of a mechanical or computerized system of bookkeeping. What that phrase modifies. And then the Law Society comes back to us telling us that that phrase modifies such cards, other permanent documents, and the information stored in a computer and retrievable in a permanent and visible form. So this is the English text. But if we look at the Chinese text, it doesn't reflect what the English text said.
Mm. 你講緊邊個字唔對啊？
Which one are you referring to? Which one are you referring to in the Chinese?
腦部嘅
There is a split in the Chinese term.
or computerized system of bookkeeping. 咁但係中文呢，佢就
In Chinese, the mechanical part is put in the middle, and then the computerized part is put somewhere else, so that the Chinese and the English versions do not tally. Ms. Lee, can you help us out? Well, I think we have to ask the DOJ's law drafting because it involves technical terms. Mr. Wong.
As far as I understand it, our law drafting division is of the view that it's not a problem at all. But then if the legal advisor has any concerns, then we can go back and take it up with the Law Society again. Well, as far as I can see it, I can understand why Ms. Wong, our legal advisor, has this question or query. All right, if possible, then DOJ will you be able to come up with a better version? Yes, we can sort it out with the Law Society. concerning the concern raised by the legal advisor. Another point is, as the case may be, there are different circumstances, and therefore you refer to as the case may be. Usually it will be placed at the end of a sentence, but then now it's placed in the third. All right, you have 1, 2, 3 parts, but then you're putting it before the third leg, and it only refers to one scenario. But then you say that, in fact, there is only one scenario, but then you talk about as the case may be. So do we really need to have those words, as the case may be? Because even if those words are crossed out, it doesn't affect the overall meaning. So either is a hard copy.
係擺尾㗎嘛，同埋有冇需要咧？點解我會特別提到 as？
The reason why I'm raising this, that's because when I talked to the Law Society, in the process of our discussion, they said that depending on the circumstances, including blah blah blah, and what I suggest is, well, depending on the circumstances, then it's not as the case may be. Shall be deemed to include. It's not as the case may be.
Would there be any difference if all these 4 words are deleted?
Can we just delete as the case may be?
Now my brain is racking as to how we got all of this, and
We are all racking
I'll tell you why. I'll tell you why. Some people aren't very good at keeping their accounts, and what they do is some firms who are sole proprietors on the back of an envelope type of accounting, and that's the reason maybe because people just do their records. They're not very good at doing it. They're just a sole proprietor. They don't get any real advice, and they create their accounts in a very vague way. So that was the answer why that was put in. But if you want to throw it out, I don't think it's going to cause me any problems. But it may cause people to be inexperienced. Of the number of law firms in Hong Kong, most 70% sole proprietors or partnerships, and they have a real problem in sometimes trying to get their accounts together. And some of them don't even do the accounts. They don't even deal with clients' money. Then all of a sudden they have clients' money. So that's why that word was put in there as well.
As the case may be, can it go to the end of Rule 10, is it C? So we put as the case may be at the very end of the third subprovision.
And I also want to read from a guide to styles and practices issued by the Law Drafting Division of the DOJ. It says, the expression as the case may be is often used unnecessarily in legal writing. Avoid it, but if without it there can be ambiguity, consider recasting the provision. So my question is it necessary?
So, can you repeat? Because we are talking about Rule 10.5.
Sorry?
I found the case by the further up, didn't I? Let's go to the other case.
Is the case
And at the end may work very well for me. I think you can put it at the end, actually. It'll have the same effect. Or as the case may be at the very end, I'll be fine with that. It's what you do, just put that.
好，
Maybe. Or,
大家其他委員同意。
I'm happy to.
Members, do you agree? Okay.
maybe in Rule 10.5, put at the end of that sub-Rule 5, right?
Yes. Or my question is it really necessary? Because even if you need it, it is usually put at the end of the sentence. And
You have another case maybe in Rule 2. Also.
And then my next question is it really necessary, given the modern trend of drafting?
But if you look at Rule 10, sub-Rule 2, the phrase as the case may be is in the middle, not at the end. So that's why I think the OJ as the case may be in the middle of
No,
subcommittee.
I mean, Mr. Cohen has already said that you're happy to put it.
I'm happy to put anything in which makes it easier and understandable, which it makes it. It
I think
seems to be.
I think it's
drafted.
sufficiently clear now if it's placed at the very end.
I can put this at the very end. I don't think it makes any difference whatsoever.
I don't think we need to debate about where exactly, but at the end is fine.
And
Mr.
then-
Wong?
Yeah.
利用呢個機會都係澄清下，因為我
I'd also like to take the opportunity to clarify that the draft was not prepared by the DOJ, it was prepared by the Law Society. We just gave our view and observation with regard to the formatting of the drafting from the drafting perspective, and if you just ask the DOJ to do it, then I'd like to clarify it. If there is anything that we can do to upgrade or to improve the drafting, we have no problem whatsoever.
Quick review.
Okay, thank you, Mr. Cohen.
It'll work.
I have one more question on this.
Yeah.
Rule 5. Let me see. It mentions such cards.
We're looking at
At the left-hand side.
Section 10, sub-rule 5.
Yes.
In this rule, each of the expressions,
Yes,
book, ledger, and record.
yes. Shall be deemed to include a loose-leaf book and such cards or other permanent documents. Such cards, usually when the cards have been raised for a second time, you use such. But here, cards is raised for the first time. So, should it be changed to any or what? Such cards here is raised for the first time.
Shall be deemed to include a loose-leaf
So
book.
to say such cards
Any card
is
So instead of such, we use any, and then we cancel. Do we use card or cards?
Cards, because it's an old-fashioned bookkeeping thing where people put these little things on the cards, and it's very, very old-fashioned, so that's why we have that.
Okay,
Some
so can
people
we
do that.
change the word such to any? So it reads any such cards
Yes.
or other permanent
Yes,
documents?
absolutely.
Okay,
Any
thank you,
such
Mr.
cards.
Cohen.
Yep.
Um,
I'm happy with that.
仲有一個係咪？
Actually, we got other volumes.
Junction with the phrase that are necessary for the operation of mechanical or computerized system of bookkeeping. This is connected, the word such. Because if you read the whole sentence together, such cards or other permanent documents, blah, 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 and then coming to the end, that are necessary for the operation of a mechanical or computerized system of booking. So is the word such related to this phrase, this clause?
Yes.
Such cards that are
because
necessary.
I noted that the Chinese rendition, they use 任何.
Oh, I see.
Yeah. So, and because it is raised for the first time.
As long as it's clear.
All right.
Going back to proposed Rule 6A at
6A.
page 4 of the markup version,
English or Chinese?
English.
English. Page 4,
Yeah.
6A, interest on client account.
Ah, yes.
Here, inquiry have been made with the Law Society on the words used, and the words are interest earned and interest accrued. For interest earned, they use 賺取的利息. Interest accrued, they use 衍生的利息. And I was asking whether there is any difference in the term used, and they replied no. And I just wonder whether the Law Society would consider adopting a single word when there is really no difference in the meaning.
Mr. Cohen?
Translation, pass it over. I can't answer that, to be honest.
It's not only translation, because
It's accrued and...
earned and accrued.
Well, yeah, well, accrued interest is interest which will accrue on the account, as it builds up all the time.
Yeah.
Earned interest is a specific amount which you may get immediately. Interest earned is different from interest accrued, actually. So interest earned is the interest earned on the actual amount when you know that. The interest accrued is the rolling over basis as well. So this is why, the rules, the English rules to me make a lot of sense, a lot of common sense. If you can translate it, by all means. But the accrued and earned are slightly different because you're accruing it up all the time. That's one area. So it's interest upon interest. Earned is when you get the interest as well. But again, at 0.0001% at the moment, while this is all suspended, it's academic.
Yes. If that is the case, I will liaise with the Law Society on a consistent use of the word for interest earned and interest accrued.
For the Chinese, yes,
the
fine.
Chinese.
I'm very helpful. That'll be very, very helpful.
李小姐有冇補充？
Very helpful to do that as well.
Silly, do you have anything to add? Sorry, Ms. Leung. Ms. Priscilla Leung. Concerning the Chinese version, should we be using the word 顯生? Should we be using 積累? Because the Chinese term 顯生 might be problematic.
Yeah.
Interest derived.
Accrued
顯生 is interest derived. Accrued should be 累積. Maybe, as Ms. Wong just said, the Chinese version can be improved. I've checked the dictionary, a glossary of financial terms. So there is a comparison between the words or amongst the words or terms used in the mainland, Taiwan and Hong Kong, and they've noticed that for interest accrued in similar circumstances, they would use the term 累算利息. I think that would be better. It's not 顯生, because from 顯生you cannot see the meaning of accrue. Because for Lehman Brothers mini bonds, derivative or derive means 顯生. Yes, Ms. Lee, do you understand that? Yes. All right. Maybe legal advisor can give us a letter setting out all these. We don't have to do it in such a complicated manner. All right. Both members and the DOJ colleagues have already made it clear as to what needs to be changed. I don't think we need to have another round of correspondence. That would be time-consuming. So my suggestion is, after the meeting, well, why don't you just sit down and sort things out amongst yourselves? Because there are only 3 points, because I can also remember those 3 points. I don't think there is any need for us to write to one another. There is another point, just one more point. Page 4.
On subparagraph 3B. Here it mentions on receipt of the client's request for a certificate, and then the council must do something. And here I'm just asking for the time frame, because the council must do something on receipt of the client's request. And here the rendition in Chinese is 在接獲後, and it talks about a time frame. It's not 在接獲時. So I'm just wondering, what is the time frame? Or are you referring to a specific point of time or a period of time? Because the use of 後 is more refers to a period of time rather than a specific point of time. And I must mention that on another occasion in the same rule, when on receipt of is used, the rendition is 在接獲時.
Translation, isn't it? I think the issue is the council must investigate, and it will investigate as it, in the time frame it thinks fit. I mean, it's like many issues with the Law Council. Someone says you must, in a disciplinary matter, the Council must do this. It's not saying how it must do it within 1 day, 2 days, 3 days. It must investigate, and in due course, it will issue its certificate. I don't think you're going to put in time periods for the Council. It must do it within so many days, so many days, so many days. It's rather like under the disciplinary proceedings. You may, if you must do A, B, and C. You do it. That's why I look at it.
Then would it be more accurate to say after receipt of? Because on seems to point to a specific point of time.
Yeah, I mean, that sounds to make a lot of sense. After receipt, it will do that. Okay.
Seems acceptable to me.
It is
and
acceptable
members,
to me.
And,
我都係問同一個問題。
okay.
因為
I was going to ask the same question.
Yeah, I mean, you can't.
Yeah, you can't say as when as at the
Upon
the
receipt.
Yeah, upon
Okay.
receipt.
咁中文使唔使改啊？
How about the Chinese version? Do we have to change that as well? Well, the current wording is already after receipt of blah blah blah. So that's the meaning of the Chinese version. All right. So that's not a problem.
係咁多，睇先。
After receipt, that's fine.
$151係咁多啦。
係that's it for 154. So we move on to 152.
係152。
Again, we'll only focus on the really controversial parts. And for the other parts, we've heard Mr. Wong said that the DOJ doesn't have any issue with any particular bit of the proposed rules, and we'll take it that the government is happy with it. And unless the Law Society wishes to change it, we'll leave it as it is. But subject to what Ms. Wong, the legal advisor, has to say. Okay?
Yes. On page 1 of LN 152, my only inquiry is on the use of 儲蓄帳戶 for deposit account when that word is already used as the rendition for savings account. And I would ask the Law Society to consider using 存款帳戶 as in the banking ordinance.
我哋睇緊152嘅中文版。
We are reading the Chinese version of LN 152. The second, under client account. This is about the Chinese rendition for deposit account and savings account.
You have a normal bank account because you look at it carefully. Client account means, it's a current account or deposit account. It can be any bank account to put it in. I mean, the English looks good to me. I can make no comments on the Chinese translation.
李小姐
Ms. Lee. In Chinese, 儲蓄帳戶, is it a broader term? If you say 存款帳戶, it seems the definition is rather limited.
Deposit account is wider than savings account. But since there are two words, deposit account and savings account, in the rules, maybe we should also use two words for the rendition. Just as in the banking ordinance, they also use two different Chinese words for deposit account and savings account. So I'm asking, maybe we should achieve consistency.
應該係存款帳戶。
存款帳戶。
我明白喎，李小姐。
Ms. Lee, I understand this point. Deposit account in Chinese, 存款帳戶 is a broader term which can cover different types of accounts. More than the term 儲蓄帳戶, which means in Chinese, which means savings account. Is it okay with you? Is it okay with members then? Okay.
係啦，改中文嗰個由儲蓄帳戶改成存款帳戶，咁就比較闊少少。咁153最後。
153，先。
Yes, Mr. Abbott.
Stating the meaning of client account only to accounts located in a bank in Hong Kong.
The reason for that is when it comes to disciplinary matters, we've had real problems with people putting their client's account out of Hong Kong. When we come to intervene or deal with matters, you cannot get the information, nor can we get control of the bank. For example, I've been appointed intervention agent on many occasions. The real problem is getting in and getting control of the bank accounts. Could you imagine trying to get into control of bank accounts in BVIs in other countries as well, and we wouldn't have any ability to control or look after the client's monies in the event of intervention. So the main objective is to keep the bank accounts in Hong Kong to protect the people of the public of the matter of Hong Kong. As simple as that.
So the legal consequence of this rule is that a solicitor firm shall not deposit clients' money
in any bank,
overseas account.
Correct.
So that is the
yes, absolutely. Because when we come for difficulties, when we have to intervene, as you've seen, and it's becoming quite a few recently, and I've become an intervention agent, I have enough trouble getting an order from a Hong Kong court to get control of it. So could you imagine trying to get a control of a bank account and if in BVI, and if somebody got smart and put it in some weird place, we could get no money out of it. We could be left chasing our arms for a long time. So that's why we changed the rules for that.
But there is a waiver provision in Rule 15.
Yes, there's always.
How is he going to be applied?
Well, the count for waivers, like anything, for waivers of rules, like for the accounts, you've got to come with a very good reason to waive, and it's up to the council to consider waiving things in respect to matters.
So it has to be dealt with on application.
On application for waivers for everything. It's quite common in all the other rules, Mr. You've seen it before in many ways.
So, in other words, the solicitor shall not deposit clients' money in an overseas account, even on client's instruction.
Yes, correct, absolutely.
Unless there is a waiver.
Unless there's a waiver, and the chance of that being given, I think won't ever be given. I can't see that happening. And that becomes the reason why that came in is that I made sure that came in because when I did an intervention, people lost their money, and we couldn't get the money because the account was really in the middle of, where was it? It was Spain. It was really something very stupid. And then you trying to get a control of the bank accounts in Spain, and the people saying, well, why did this happen? And we're not controlling our members. So that's why.
But prior to the enactment of this rule, solicitor can do it. Can we outside?
Yes, but there've been technically, but there's been some. We changed. We did a practice direction out saying they can't. Correct. Yeah, before the change there's ambiguity in respect of all of this, but we've made it very clear. I think there was a practice direction that came out saying that you can't do it. So you're in breach of the practice direction. I think a practice direction came out some time, but we need to get this into the rules to stop this happening. And this is quite an important one, which, we need to do.
Thank you.
I understand from Ms. Wong, thank you very much, Ms. Wong, that we have come to an end of the controversial issues. So there are no more. And given what the DOJ has said, that the Law Society proposed amendments to the rules are all acceptable, save for the 4 points which we've just discussed, and which you have agreed to go away and amend. Now, let me consult with the Secretary to see how we could do it, because there are some time limitations.
Chairman, depending on whether there is a need to call another meeting to look at the amendments, if members of the view that that can be done by circulation, and if members have the need, then we may call the meeting. But there is a deadline on the 5th, which is on the 5th of December. So on the 23rd of November, we have to submit a report to the House Committee. And members' notice of amendment will be on the 28th of November, the latest. If we need another meeting, we should have it before the 23rd of November. Ms. Abbott-Ho, I think it's very simple and technical. Just do it by circulation. If everybody is agreeable, then we don't need another meeting. No, we really don't need a meeting. Let's do it by circulation. The Law Society will send the amendments to the Secretary, and then we will circulate the amendments, and then members can look at them, and then I will report to the House Committee.
So we've drafted the amendments just right now, so it will take, hopefully, within the next 24 hours, we can get something out. I think Angela's looking very strongly at me now, a little bit longer than that.
You just ruined her next few days.
No, I haven't, because we've got I got overseas lawyers qualifying examination tomorrow, so I've got to get this done before I have to start.
I think it's in the interest of everyone that Law Society really come up with the agreed amendments within the next few days, so that we could circulate within the members and the subcommittee. And then we'll hopefully pass it without further comments and objections. And I'll thank you, Ms. Lam.
Can I go?
Mr. Cohen.
Yes.
I've just been reminded by the Secretariat that please provide both English and Chinese versions when you give us the amendments that has been agreed on just now. Okay?
Yep.
Thank you. And also, Ms. Wong has suggested that you provide an information note explaining. But look, for future references, so that we could save some time, instead of asking you these questions here, we would know in advance the meaning behind your suggested proposals. Thank you.
We take on board those comments. We'll do.
Thank you very much.
Thank you.
其他委員有冇問題？冇。OK，三。
Any questions, members? No. Meeting adjourned.